I'm Vinita Patakamgai. I'm from Sydney campus. For this question, I use the IRAC method and the case married versus married, the case of 1970, which is an English contract law, and it is the matter of creating legal relation. This case falls under the principle laid out in Balfour versus Balfour. It is the domestic agreements between a husband and a wife which are rarely legally enforceable, where the principle was rebutted, where the husband and the wife who formed an agreement over their matrimonial home were not in a good term. The jointly owned house by Mr. and Mrs. Married. The issues arise when Mr. Married left to live with another woman. For this, they made an agreement where Mr. Married should pay Mrs. Married a $40 monthly, and later he transferred the house to her. If Mrs. Married kept up the monthly mortgage payment, when the mortgage was paid, Mr. Married refused to transfer the house. The nature of the dealing and the fact that the Marrieds were separated when they signed their contract allowed the court to assume that their agreement was more than a domestic arrangement. The Lord Denning stated that the husband and the wife were married as long ago in 1941. After the war in 1949, they got a building plot and built their house. It was a freehold house which is situated on Clayton Road, Hook, Chasington. It was in the husband name with a considerable sum on mortgage with a building society. In that house, they have spent many years by growing up their 3 children, and the wife was working mother and contributed to the household expenses too. And in 1966, they come to an agreement where the house was to be put in joint homes. The Court of Appeal distinguished this case reference to Balfour versus Balfour, which I have already stated previously, and the spouse have separated, which is generally considered that they do intend to bound by their agreement. The agreement signed was further evidence of an intention to be bound. I think in this case there is no application, as the husband are living under a legal amity, because the parties they were involving together in this case the parties they were involving or living together in amity. In such cases, their domestic arrangements are ordinarily not intended to create the legal relation. It is altogether different when the parties are not living in amity but are separated or about to separate. Then they bargain keenly, they do not rely on honorable understanding, and they want everything cut and dried. It may safely be presumed that they intend to create legal relation. But for that element of uncertainty, I'm sure the majority would have held the agreement to the binding. They did not differ from the general proposition. In all these cases, the court does not try to discover the intention by looking into the minds of the parties. It looks at the situation in which they were placed and asks itself, would this agreement was uncertain because of the arrangement for $40 month maintenance, or that is obviously untenable. Next, he said that there was no consideration for the agreement. That point is no good. The wife paid the outstanding amount to the building society. That was a ample consideration. It is true that the husband paid her $40 a month, which she may have used to pay the building society, but still her act in paying was good consideration. And in a concluding, I can say that Mrs. Married won the case, and finally the house belonged to her. It is a case of domestic agreement between a husband and a wife which binds not living in an amity. Thank you.